March 9, 1933, The Quiet Coup, a constitutional analysis of commercial jurisdiction and civil deception. 1. The day sovereignty was suspended. On March 9, 1933, the United States Congress, operating under emergency conditions, enacted provisions under the Trading with the Enemy Act, effectively declaring a form of national bankruptcy. This legislative maneuver enabled the United States, redefined as a corporate entity, to operate beyond the constitutional boundaries previously established by the framers. President Franklin D. Roosevelt's rhetoric, though famously tied to another date, applies presciently to this day as a pivot from constitutional republic to commercial regime. 2. Jurisdictional usurpation, courts and corporate governance. Following the 1933 developments, judicial authority was incrementally transferred from constitutional courts to administrative and commercial tribunals governed by federal procedural rules. These now supersede state sovereignty in practice. The visual indication of this jurisdictional shift is symbolized by the gold-fringed American flag, denoting maritime or Admiralty jurisdiction, often observed in modern courtrooms, an overt assertion of foreign corporate authority. 3. Contracts as instruments of enslavement. In commercial jurisprudence, all matters are resolved under the Uniform Commercial Code, UCC, which governs contract law in the United States. A valid contract under the UCC requires mutual consent, disclosure of all material terms, and signatures of all parties. However, unilateral contracts, often executed under asymmetrical knowledge and hidden stipulations, have become standard in consumer and government agreements. Without informed assent, these instruments are deceptive by design and function as mechanisms of coercion. 4. The construct of the strawman. Governments create corporate fictions, referred to as the strawman, by registering birth certificates in capital letters, converting living individuals into legal entities under administrative jurisdiction. This legal fiction allows corporate governance to treat the person as a debtor or surety. A living man or woman, signified by proper capitalization and the pronouns I, me, my, or myself, is therefore administratively subordinated through deception to a trust structure created without knowledge or consent. 5. The lawyer as corporate proxy. Attorneys, officers of the court, function as proxies for the corporation state in judicial matters. Their license, often issued under the British Accredited Registry, BAR, situates them as fiduciaries of the corporate judiciary, not as advocates for the sovereign individual. Most legal representation occurs without informed disclosure of fiduciary conflicts or the structural limitation that attorneys cannot speak on behalf of a living man or woman, only for legal persons, i.e., entities. 6. Legal fiction and the weaponization of consent. Legal proceedings today are often triggered through voluntary submission, typically by acknowledging jurisdiction via plea, signature, or verbal declaration of one's legal name. Jurisdiction is contractually conferred the moment an individual consents by engaging with the court, and such courts do not possess inherent constitutional authority unless invoked through the proper channels of due process. This renders most judicial outcomes a product of manufactured consent. 7. The procedural trap, from code to incarceration. Contemporary criminal and civil courts often conflate jurisdiction and adjudication under administrative procedure. Pleading not guilty or no contest affirms the court's authority. Defendants, often misled by counsel into complacent compliance, are effectively coerced into self-conviction. Sentencing becomes a function of manipulated assent, rather than justice, with the legal system operating primarily under procedural commercial rules, not under substantive constitutional law. 8. Enactment and the constitutional void. For a statute to have lawful authority, it must be passed through an enacting clause grounded in the state or federal constitution. However, Many codes, regulations, and administrative rules now enforced lack such constitutional anchoring. This legislative bypass has led to the proliferation of non-laws enforced as laws, rules that possess the color of law without lawful foundation. Any party may challenge subject matter jurisdiction or the validity of enactment at any stage of the proceeding. 9. Redemption and the power of response. When confronted by legal claims, especially those originating from third-party lawyers or administrative agencies, the proper sovereign response is to accept for value or return unsigned under the Truth in Lending Act. Consent must be withheld, and contract formation actively rebutted. Non-response constitutes acceptance. Legal maxim: silence is acquiescence. Therefore, rebutting presumptions becomes not only advisable but essential to retaining jurisdictional sovereignty. 10. Legal identity, trust law, and redemption. Upon birth, a trust is formed in one's name, and the individual is recorded as a trustee of a legal fiction created under commercial law. By asserting one's position as a living beneficiary and executor of this trust, one may reclaim legal agency. The assertion of power of attorney in fact becomes the lawful mechanism to collapse the presumption of subjugation. Reasserting this authority restores lawful standing outside the administrative matrix. 11. The 7 discovery demands for counsel. When engaged by legal professionals acting under corporate capacity, the following inquiries may be made to test jurisdiction and fiduciary legitimacy. Produce the legislative act and implementing regulation underpinning this cause. Identify the legislative basis and licensing authority for the office of attorney or counselor. Present your oath of office and its public record filing. Submit a signed agreement indicating I waived constitutional rights. Disclose your full contact and professional information. Provide bond number and insurer identity. Acknowledge your constructive fraud or perjury, if applicable. These inquiries expose foundational gaps in assumed authority and may be used to rebut jurisdiction. 12. From prisoner to party, the power of language in court. Many individuals unknowingly convict themselves through poorly informed courtroom responses. Judges rely on scripted questions to elicit compliance. When individuals affirm they received a fair trial or accept a recommended sentence, they unknowingly finalize jurisdiction. This ritual is compounded by legal counsel who coach clients into submission. Sovereign individuals must reject jurisdiction affirmatively and unambiguously at every phase of the proceedings. 13. Reconstructing legal frameworks and restoring sovereignty. The distinction between code and law has been obscured through administrative reclassification. To reconstruct lawful governance, individuals must assert the necessity of enabling clauses for legislative acts and demand due process grounded in constitutional authorization. Any regulation not grounded in an enabling clause is presumptively void. Informed challenge of jurisdiction and statutory origin is not only lawful, it is the cornerstone of republic preservation. 14. The redemption process, legal autonomy through contract law. Redemption through contract rejection and assertion of sovereignty requires precise adherence to contract principles. All communications from third-party attorneys or agents must be returned or rebutted. Acceptance for value, refusal for cause, or conditional acceptance are lawful tools. Failure to rebut presumption creates adhesion contracts, which may be enforced by courts under administrative rules. Contract silence is a confession in equity. 15. Reclaiming the estate, birthright and the strawman separation. The state converts birth certificates into financial instruments, securitized and bonded via the Social Security Administration. Each individual becomes a registered trust, with the strawman acting as surety. Upon awareness, the living man or woman may separate from the strawman and reclaim their estate through lawful filings and the execution of power of attorney in fact. Sovereignty is not granted by governments, It is reclaimed by the governed through commercial competence and unwavering intent.